All right. So the background of this is you may have hired a new marketing person at your group practice or at your ASC or your hospital. They come in with a bunch of really good ideas about how they can market your particular healthcare services. The problem is, unless they've been around healthcare for a while, they may not realize that a lot of the things that you could do in other industries, you simply can't do in the healthcare industry because of particular laws and regulations that are specific to healthcare industry, particularly the fraud and abuse laws. So we're going to talk about those fraud and abuse laws, talk about HIPAA, some rules concerning telemarketing, false and deceptive marketing or advertising, some certain limitations that apply to particular marketing or industry segments, and then I'm going to wrap up by talking about or giving you a few suggestions for reviewing your marketing policies or strategies. We're going to be going awfully fast, but hopefully nothing of this stuff is new, and it'll just be a good reminder to you of the things you need to watch out for. As far as written materials, we provided you with a copy of the PowerPoints, several other materials. Particularly, I'd encourage you to take a look at that OIG Supplemental Compliance Program Guidance for Hospitals. Even if you're not a hospital, it's a good idea to take a look at it because it gives you an overview of the rules concerning the fraud and abuse laws and certain other laws that come into play when it comes to these marketing programs. In addition, you really need to take a look at the Special Advisory Bulletin concerning offering gifts and other inducements to program beneficiaries. If for some reason you didn't get those written materials, then shoot me an email. We'll make sure we get those to you. This program, like all of our programs, are going to be recorded, and they'll be available for replay if you want to go back there and look at it again. And because they are recorded, we won't take any questions because we don't want any embarrassing or potentially adverse comments made on the program that could come back and haunt our participants. So, therefore, if you have any questions, go ahead and submit them using the chat feature or shoot me an email offline, and I'll make sure that I get back to you. Now, we're going to be talking about a bunch of stuff here today, but we're going to be focusing on federal laws. Not all laws, just those laws that are the most relevant to the things that we're talking about today. So just remember, we're going to be providing an overview. Additional state or federal laws may apply, particularly state laws. Because we've got so many people from different states, we're really going to focus on the federal laws today. So when it comes time to actually applying these rules, make sure you're aware of what your own particular state law requires. Also remember that the rules differ depending on your circumstances. For example, the different payer types or the types of services for which you are marketing. Those things can affect application. I'll try to address those as we go through. All right, let's get into it. Let's talk first about the federal fraud and abuse laws. You guys get tired of me talking about these laws, but you got to be careful because, again, any marketing techniques that you're doing in the healthcare industry, they may implicate the federal fraud and abuse laws, including the Anti-Kickback Statute, STARK, the civil monetary penalties laws. Those laws generally apply if you're dealing with program beneficiaries, federal program beneficiaries like Medicare or Medicaid, TRICARE, or if you are making referrals for items or services that are payable by federal health care programs. Anytime you do a deal with the government, like you accept payment from Medicare or Medicaid, there are always strings attached. Some of those strings are the STARK, the Anti-Kickback, and the CMPL law, the Civil Monetary Penalties law. So if you're dealing with federal program beneficiaries or items or services payable by federal health care programs, you got to be concerned about those federal fraud and abuse laws. Now, in addition to the federal laws, you also have to be aware of your state laws. The state laws vary by state. Some of them only apply to government programs. Some of them apply to all programs. Some of them will have, basically the equivalent of the federal STARK and anti-kickback statutes, but you may also have fee-splitting statutes, patient brokering statutes, or other statutes. So make sure you're aware of the rules that apply to your particular state. Let's talk first about the federal STARK law. This applies anytime you're doing any kind of a marketing arrangement in which you are benefiting a physician or a member of the physician's family. STARK says that if a physician or their family member has a financial relationship with an entity, like a hospital, an ASC, or another entity, The physician may not refer the patients to that entity for certain designated health services, and if there is an improper referral, that entity, that hospital, may not bill Medicare for such designated health services unless you've structured that arrangement to fit within a regulatory safe harbor. So, for example, if you want to pay a particular physician to perform research for you or other methods, other actions as a marketing gimmick in order to get their referrals, you need to make sure that you've structured that in an appropriate way to fit within a safe harbor. If you don't, then that physician either can't make referrals to you, or if they do make referrals, you can't bill for them. If you do bill for them, lots of penalties can rain down upon your head, including you can't get paid for those services. If you did get paid for them, that's an improper payment. It would require an overpayment under the report and repayment rule. Civil penalties under STARK is $15,000 per claim submitted. If you fail to report and repay within the 60-day time period under the report and repayment rule, you could also get hit up with False Claims Act penalties of $5,500 to $11,000 per claim. You can get hit up with trouble damages, exclusion from Medicare and Medicaid, and a whole bunch of bad stuff. The bottom line is, anytime you're doing a marketing deal with or that benefits a referring physician or a member of the physician's family, you need to make sure that you've structured that deal to fit within one of the STARK safe harbors. Some of those potentially relevant safe harbors are employment contracts with the physician or the family member, maybe an independent contractor agreement, maybe a contract for items or services that are provided to the physician. There are certain benefits for incidental medical staff benefits and the like. When testing your compliance with each one of those, it's important that you satisfy each one of the elements in those safe harbors. If you don't, then you fall out of compliance and it can result in serious fines and penalties. Okay, that is STARK. The next one you have to be concerned about is the Anti-Kickback Statute. The Anti-Kickback Statute is actually much broader than STARK. STARK only applies to referrals from physicians. The Anti-Kickback Statute applies to your financial relationship with anybody who may be a referral source. It could be other providers, it could be patients themselves, it could be patients who are referring other patients, it could be your employees, anybody whom you are paying or rewarding to provide referrals. The Anti-Kickback Statute says you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by a federal health care program unless the transaction is structured to fit within a regulatory safe harbor. Now, unlike STARK, which is a strict liability statute, the Anti-Kickback Statute is an intent-based statute. You've got to act knowingly and willfully. But that's a low threshold for the government to establish under the what's called the one purpose test. The Anti-Kickback Statute is violated if one purpose of the remuneration is to induce referrals, even if there are lots of other legitimate purposes. Now, these can arise quite often the Anti-Kickback Statute can be implicated by your marketing programs. The OIG, the Office of Inspector General, specifically stated that the Anti-Kickback Statute on its face prohibits the offering or acceptance of remuneration for the purposes of arranging for, recommending the purchasing, leasing, or ordering of any service or item payable by Medicare or Medicaid. Thus, we believe that many marketing and advertising activities may involve at least technical violations of this statute, because really that's what marketing is, isn't it? You're trying to get those people in to get your services, and if you're offering any kind of inducement to get them in to purchase your services, hey, that is a potential anti-kickback statute. Last week, my wife and I went shopping for a car. We were offered all sorts of inducements to buy the car. If we bought the car, we would get this service or that service. Guess what? That may be okay in the car industry, not so good in the healthcare industry. What happens if you violate the anti-kickback statute? Hey, you go to jail for this one. The penalties are up to 5 years in prison. It's a felony, $25,000 criminal fine. Under the CMPL, you can get hit up with an additional $50,000 administrative penalty. 3, treble damages, exclusion from Medicare and Medicaid. In the wake of the Affordable Care Act, a violation of the anti-kickback statute is also an automatic violation of the False Claims Act, which means you can get hit up with the additional penalties that are available under the False Claims Act. The bottom line is, you don't want to go anywhere near that. You want to make sure that your deals are structured to comply with that anti-kickback statute, including perhaps an anti-kickback safe harbor. Possible safe harbors for anti-kickback situations involving marketing might be paying your employees a bona fide payment for their services, independent contractors agreements that are set up to comply with the safe harbors, certain recruitment safe harbors, things like that. The key here is that in order to get the benefit of the safe harbor, you've got to satisfy all of the conditions in the safe harbor. Now, in the Stark law, because it's strict liability, if you don't comply with all the technical requirements, then, hey, that's a potential violation. Under the anti-kickback statute, because it's intent-based, you are not required to comply with the safe harbor, but if you don't, then the test is one purpose of this deal to generate referrals. And if you're talking about a marketing deal, hey, that's what you're there for. So you have to be careful. The government has published a lot of advisory opinions concerning application of the anti-kickback statutes in the marketing context. If you can't fit within a safe harbor, you could go to those advisory opinions and see if there is one that is relevant to your particular situation. It would not be binding upon the government in their interaction with you, but it would give you some guidance on how the government views that particular type of situation. All right, the third element in Satan's trifecta here is the civil monetary penalties law. Like the anti-kickback statute, it applies if you are marketing government program beneficiaries or government program business. Specifically, the civil monetary penalties law prohibits a bunch of different types of conduct, but in particular, for purposes of our discussion today, it prohibits offering, soliciting, or receiving or giving remuneration to induce referrals, i.e. kickbacks, same thing as the anti-kickback statute. In addition, the civil monetary penalties law prohibits offering inducements to program beneficiaries if you know or should know that that remuneration is likely to influence that beneficiary to order or receive items or services payable by federal or state programs from a particular provider. So, for example, let's say you want to go out and convince Medicare beneficiaries to come to you to get certain types of services at your facility. If you are offering inducements in order to get them to come to your facility, that is a potential civil monetary penalties law violation in addition to a potential anti-kickback statute. So, for example, if you're driving down the highway, you see a big sign up there for a hospital that says, hey, deliver your baby at this particular facility and we'll give you free diapers for a year. Well, is that an inducement to try to get that person to come to deliver that baby there? Yeah, probably is. In that situation, if those services are payable by Medicare or Medicaid, then there is a potential anti-kickback and TNPL violation. All right, let's talk about applying the fraud and abuse law. So here you are, you're in your marketing meeting. You got your marketing specialist that's up there talking about your strategic plan. Stay with me, people, because in step C, things get a bit delicate, either immense profit or federal prison. That's basically how it works when you're talking about complying with the federal fraud and abuse law. So let's apply some of those to common situations. First, what about if you want to offer free or discounted items or services to patients? That could be free items to induce the purchase of items or services, like I mentioned, offering free diapers or other supplies in exchange for getting their services at your facility, sending gift cards, offering gift cards, giving gift baskets as a reward for getting the services there, offering free services to induce referrals for other items. Maybe you are a home health care provider and you say, we will provide you home free lawn care if you get our home health services, or that type of a situation. It could be offering discounted items or services in order to induce the purchase of other items or services. You're offering a loss leader in order to get them to induce them to purchase other items. Could be offering rebates, thank you gifts, insurance-only billing, free transportation. Anytime you are giving free or discounted items or services to induce someone to order or receive items or services that are payable by federal health care programs, you need to be concerned about the anti-kickback statute. Now, there are some exceptions. If you're dealing with government program beneficiaries, so you have some kind of a marketing plan that's geared towards Medicare program beneficiaries or patients whose services may be payable by Medicare, Medicaid, or other federal program, the government has said, we won't go after you if you limit that benefit you're offering to an item or services of low value. Now, they interpret low value to mean if each item or service that you offer to that patient is less than $10 and the aggregate that you offer to that patient in any year is less than $50. So you could have a benefit where you offer a free gift card that's worth $9 to a patient, so long as you only give, you know, I guess 5 of those to the patient per year. That would get you out of the civil monetary penalties law, probably also the anti-kickback statute. There's also exceptions for certain incentives for certain types of preventative care, perhaps mammography under some circumstances, other types of certain types of preventative care that are set forth in the regulation. There's an exception for remuneration that promotes access to care and poses a low risk of harm to patients and government programs. We don't have a lot of specificity on what the government means by that, but theoretically, if you're offering these freebies that's going to promote access to care and at the same time there's a low risk of harm to the patients or the government program, then theoretically you might be able to structure that marketing campaign to fit within that exception. There are exceptions for retailer coupons, rebates, or rewards offered to the public. Those are retailers. Those are like the pharmacies or the grocery stores, not necessarily you as a physician office or a hospital. Those are situations involving government program beneficiaries when you're going out to government program patients. Well, what about if that is not a patient whose services are payable by government healthcare programs? What about private pay patients? Well, you need to check your state laws and see what those state laws would say, whether or not they prohibit offering inducements for private pay patients. But be careful. Sometimes I've had situations come in and they will have some kind of marketing campaign that they will say, hey, patients, you come to us and we will give you this freebie, but we know we can't violate the anti-kickback statute, so we're only going to give you this freebie if you get items or services that are not payable by federal health care programs. We're going to carve out the federal programs for those benefits. Now, the problem with that is the OIG has looked at that and said, well, wait just a minute. If you're offering those freebies, those inducements for non-federal program business, that patient may also come to you for the federal program business. And therefore, you're really offering it to get the federal program business too. And so we reserve our right to take a look at that, and depending on the circumstances, we may come after you. So don't necessarily count on those carve-out programs. They may or may not protect you. Just be careful about that. Well, what about insurance billing? Maybe you've been driving home from work and you hear those advertisements that come on that say, hey, they're usually from like a windshield repair place or maybe a chiropractor that says, hey, come to us. We will not bill you personally. We will only bill your insurance. We will write off any copay or deductible that you might have. Is there a problem with that? Yeah, especially if you're dealing with government program beneficiaries, because that is, based on the definitions, that is a violation of the civil monetary penalties law. Now, you may think, well, why does the government care? Because I'm just giving up something that the patient would pay me otherwise. But the problem is, if that patient doesn't have to pay the copay, then that removes the disincentive from them for getting the care, and it screws up the actuarial tables, and it also increases the likelihood they're going to get care, get services that may or may not be necessary, and the government doesn't like that. So they specifically said if you're offering that insurance-only billing, the waiver of copays and deductibles, you're offering an inducement that could violate the civil monetary penalties law or anti-kickback statute. There are a couple of safe harbors. You can waive copays or deductibles if there is a good faith determination of financial need, or you've tried to collect but you can't collect, and you're not offering that as part of some kind of advertisement or solicitation. So you're not out there advertising, hey, come to us and we'll only do insurance billing. And it's not offered on a routine basis. It's not part of a marketing ploy, okay? In addition, there is a specific exception under the anti-kickback statute whereby a hospital may waive certain waivers or copays for hospital inpatient stays under the PPS program if certain conditions are satisfied. Now that's the federal programs. Bottom line is, hey, you can't waive copays and deductibles absent a showing of financial need, a real showing, not just a wink, wink, nod, nod type situation. What about private insurance? Well, the private insurers don't like you doing this either. And if you look at your contract, it will probably prohibit you from waiving those copays or deductibles, or it may just simply say you are obligated to collect those copays or deductibles. If you're waiving that, you're violating your insurance contract. That insurer may be able to come back and sue you for breach of contract, maybe insurance fraud, or the like. There may be separate state laws that prohibit that practice of waiving a copay. For example, here in Idaho, we have a statute that prohibits a regular practice of waiving copays or deductibles. What about prompt pay discounts? As part of your marketing gimmick, you'll say, hey, come to us, and if you pay within a certain period of time, we will take off a certain percentage of the amount that you would otherwise owe us. Well, the government, if you're dealing with government program beneficiaries, again, you have to be worried about the Anti-Kickback Statute and the Civil Monetary Penalties Law, but the Office of Inspector General has approved a prompt pay discount for government beneficiaries if you satisfy certain criteria. In this particular advisory opinion, they approved it where the amount of the discount related to the avoided collection costs. So it's not like you were making money or necessarily using it to induce people to come in. You are getting them to pay promptly, because by doing so, you could actually save money by avoiding collection costs. It's offered to all patients for all services without regard to the patient's reason for admission, length of stay, or DRG. You're not just offering it for those orthopedic or other services that would generate a lot of money. It's not advertised in a manner so as to solicit the business in advance. You notified your private payers of the program, so if they had objections, they could step up, because that may be contrary to their payer contract. And the costs are not otherwise passed through to Medicare or Medicaid or other payers on your cost report, for example. So you're bearing the cost of that. You're not passing it through to the government. Even then, you have to be wary of the substantially in excess rule. There's a rule under Medicare that you can't charge Medicare substantially in excess of your usual and customary rate. If you have a regular practice of discounting these payments, then that may reduce your usual rate, and you can't charge Medicare substantially in excess of that. Now, usually that's not too much of an issue, because the number of patients to whom you provide this discount is probably going to be relatively limited. It's probably not going to be significant enough to trigger that substantially in excess rule. But just remember, anytime you're offering patient discounts, prompt pay discounts, maybe private pay discounts, self-pay patient discounts, those types of things, consider the potential effect it might have on the substantially in excess rule. Now, that's dealing with government program beneficiaries. What about private pay business? Well, again, it may affect your usual and customary charges to the extent that that is a condition in your private pay contract. You need to make sure that you check your insurance contracts to ensure that there's nothing that prohibits you from doing that. Prompt pay discounts, usually not much of a problem if you're discounting the entire payment. If you're discounting only the copays or deductible portion of it, the insurers may not like that, and so you better check your contracts, also check applicable state law. Well, what about if your marketing person comes in there and says, hey, let's go ahead and let's have a program where we offer free types of screening. Maybe it's a free diabetes screening, free blood pressure check in order to identify those patients with hypertension, that we might be able to get them into our cardiac program. Can you do that? Well, again, the question is, are you offering something free or discounted in order to induce services? If you are, that is a potential violation of the Anti-Kickback Statute. If it's offered to program beneficiaries, and it could be a violation of the Civil Monetary Penalties Law. So, in the case of government program beneficiaries, the OIG has approved free screening services or tests in advisory opinions if you can satisfy certain criteria. Specifically, they approved a situation where it was not conditioned on the use of any items or services from any particular provider, the patient was not directed to any particular provider, and the patient was not offered any special discounts or follow-up services. If the test shows abnormal results, the visitor is advised to see his or her own health professional. And it's not a situation where you come back with abnormal results and you say, oh, well, let me usher you into our primary care clinic, or let me send you right over to our diabetic clinic, or right over to our cardiac program. Those are the situations where they would be viewed as tied to or an inducement to get these additional services. Now, it may be okay to say, if your test results come back abnormal, you ought to immediately contact your primary care physician. If you do not have a physician, contact us and we will provide you with sources so that you may get a physician or identify potential physician sources, but you need to be really careful about tying those free screenings to additional services that you're going to offer. The more closely you tie those services to your other services, then the more likely it is that it would be viewed as an improper inducement. Well, what about private pay patients? Well, if you're dealing with purely private pay patients, you probably don't have much of an issue with these types of situations under the federal statutes, but you still may have a problem under state statutes. Better take a look at your state statutes. What about offering free transportation programs? You send out your van to go pick up patients so that you can bring them into the hospital so that they can receive services. Are you offering something for free or discounted, some free or discounted benefit? Yeah, probably so. If so, then you got to be concerned about the federal Anti-Kickback Statute and civil monetary penalties law if you're offering that to program beneficiaries. Now, the OIG has approved free transportation programs where, again, you satisfy certain criteria. That program is open to all eligible patients. You do not selectively limit it to certain targeted beneficiary populations like your orthopedic patients or your cardiac patients, those that would bring a high rate of return back to you. The type of transportation has to be reasonable. You're not sending out the limousine to pick up those people. The travel is local to the physicians or offices or the hospital. You're not sending them from miles away. Public transportation and parking is otherwise limited so that those patients don't otherwise have a readily accessible way to come to the facility. And the cost of the program would not be claimed on the cost report or shifted to a federal program. In 2014, the Office of Inspector General, or HHS, actually proposed a modification to the Anti-Kickback Statute for local transportation programs. I don't believe, though, that it was ever finalized. What about private pay business? If you send out that van to pick up your private pay patients, well, that again depends on your state law. Make sure you check on the state law and be careful about situations where you're bringing them in for the private pay basis, but you're really also hoping to get their Medicare business. In that situation, it might also constitute a violation of the Anti-Kickback Statute. What about drawing for a prize? You go in there and the physician office says, hey, we are going to give our patients, all of our patients, you come in, get care here, we'll give you a chance for a free cruise or a chance for a free TV or a Sony, an Xbox or something else going on there. Is that okay? Well, are you offering something of value in order to induce referrals? Probably so. So you got to make sure and see whether or not it's going to fit within a regulation or an exception. That drawing for a prize may be okay if the value of the chance to win is nominal. For example, if you take the value of the prize divided by the number of participants, so the real value or the chances of winning, you may have a 1 in 1 million chance of winning. The value of that is probably pretty limited, and it may fit within that $10 per patient limit. Now, I have not seen, quite frankly, I haven't looked for any advisory opinions concerning these particular issues, but I understand that there is some commentary out there. Before you decide to engage in that type of a deal, you may want to check under the federal law to make sure that you're comfortable with that. In addition, you've got to be aware of your state laws, because all states will have laws governing sweepstakes, raffles, lotteries. Make sure that you don't cross over the line to do something that would effectively turn you into a casino and subject you to all sorts of state law fines and penalties. All right, up until now, we've been talking about offering freebies or discounted items or services to patients. What about if you're offering those to other providers or other referral sources, whether they're another provider or not? It could be one of those refer a friend offers, right? Every time I go into my dentist's office, I see that, hey, you refer a friend to us and we will give you a $10 gift card. Well, are they offering items or services to induce referrals? Sure they are. Is it for Medicare program business? Maybe. not sure everything that that particular dentist does. Am I going to tell him about it? Heck no, not until after he finishes drilling on my teeth. But there is a potential problem for federal fraud and abuse law violations. Could be thank you gifts that you send to that referring physician, support or subsidies you may offer to that particular referring physician, free subsidized insurance, subsidized practice benefits, things like that. Free use of hospital space, equipment, or personnel, professional courtesy, paying more than fair market value for services they're providing, yada, 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 whatever it might be. If you're offering free items or services that does not reflect fair market value for services that are performed, then that may constitute a kickback and improper inducement. If you're dealing with a physician, a referring physician, or a family member, you got to be concerned about Starks. You're going to want to make sure that that financial relationship, anything you're giving that physician, any contractual relationship, other relationship you have with that physician, is structured to fit within one of those regulatory safe harbors under Stark. You've also got to be concerned about the Anti-Kickback Statute and the Civil Monetary Penalties Law if one purpose of that deal you're doing is to generate referrals. What about referral sources for private pay business? Again, if it's truly private pay, you may not have to be concerned about the federal fraud and abuse laws unless you're offering that inducement not only to get the referrals for the private pay business, but also for the Medicare business, Medicaid business, then you may be back in the soup. So be careful about those carve-out situations. Let's talk about some other specific areas that come up quite a bit. I get called every now and again. We're a hospital. Can we help advertise a particular physician in town, advertise their practice? This is a physician who's not employed by the hospital, but they're providing services at the hospital. Can we market that physician's practice? Well, by doing that, by subsidizing those marketing costs or covering those marketing costs or doing the marketing yourself for that physician, are you providing something of value? If you are, you got to be concerned about Stark and the Anti-Kickback Statute. So ultimately ask this question. Are you marketing that physician's practice, or are you marketing the hospital's own practice? Stark applies if and to the extent that you're marketing a non-employed physician's practice, you may be able to fit within a safe harbor, for example, the non-monetary compensation safe harbor if it's the value of the services you're providing are less than roughly $300 per year. Maybe if you're doing it as part of a recruitment agreement, you may be able to do it. But if not, it's going to create a financial relationship that could trigger Stark. It could violate the Anti-Kickback Statute if one purpose of offering that subsidized marketing is to induce referrals from that particular physician. The government warned against, it came out with an advisory opinion that specifically warned against offering those types of subsidies. In this particular situation, there was a DME supplier who wanted to provide free advertising or reimburse their clients for their advertising expenses associated with the DME. And the OIG refused to approve that arrangement. They specifically said that by subsidizing the advertising expenses, that supplier would be providing a valuable service to the clients, sparing them the cost they would otherwise incur to promote and operate their business. That essentially constituted a kickback, and therefore there's a substantial risk and the government could go after you for a potential anti-kickback violation. Well, what can you do? In the Stark commentary, the government has said that you can list non-employed providers on the hospital's website. So that's okay. You can do a simple listing of the medical staff members on the hospital's website. That's considered to be an incidental benefit that fits within an exception under Stark. But you need to make sure that you're limiting the scope of what you're advertising on your website if you're a hospital. If you go beyond simply listing the members of your medical staff to actually advertising or promoting that physician's private practice, the practice outside the hospital, then in that particular situation, that probably is not going to be accepted. That's not an incidental benefit, so the hospital would need to fit within another Stark exception or charge that physician fair market value for the advertising they're doing on behalf of that physician. What about if you're going to do joint marketing efforts with that other physician? Maybe you're going to go together to put up some kind of a billboard or some service line that benefits not only the hospital but that physician's private practice. Well, again, Stark applies to the extent that results in private benefit to that particular physician. You have to look for a particular safe harbor. The bottom line is this. If you're a hospital marketing a physician's practice, are you marketing that physician's private practice, or are you marketing the hospital's own practice? The hospital can always go ahead and market its own practice, market the services that the hospital provides, but to the extent it crosses the line and also starts marketing the physician's practice away from the hospital, that's when the potential Stark and anti-kickback issues rear their ugly head. Some of the factors are, does that joint marketing effort focus on the hospital service or the physician's private practice? Does it contain the physician's private contact information or only the information at the hospital? Does it contain information about the physician's private practice or only, again, the information for the hospital services? Does it promote the physician's services away from the hospital or only the services that are provided at the hospital? The more you are promoting that physician's practice separate and apart from the hospital services, the government can come back and say, no, this isn't advertising the hospital, this is subsidizing the services that are provided by that physician in his private practice. So if you want to do those joint marketing programs, make sure each party pays their fair share. That could be determined based on the relative advertising time. If you're buying media spots, it could be relative advertising space. If you're putting up a sign or a billboard, it could be the relative focus of the advertisement. Make sure that that arrangement is documented appropriately. Make sure that that physician is paying their fair share or reimbursing, maybe paying directly for either reimbursing you for the cost or reimbursing their fair share, paying directly to the entity who is actually going to do the marketing. The bottom line is, don't subsidize the marketing for that physician's private practice unless you can structure it to fit within one of the regulatory safe harbors. Well, what about paying for leads? There are some services out there that will go out there and find potential patients for you, and they will generate leads for you. Can you pay those entities to provide those leads for you? Well, if those leads are for items or services payable by federal health care programs, are you paying for referrals? When does that lead become a referral? Well, that depends on the particular circumstances. In an advisory opinion, the government approved an arrangement whereby a website sold leads to the chiropractors under certain circumstances. Specifically, the factors that the government identified are the arrangement did not target government beneficiaries, so it wasn't just out there to get government program patients. The arrangement did not actively steer patients to a particular provider. Instead, it was just kind of a general one that was out there. The fees paid to that entity that was provided the lead generation services did not depend on whether the lead became a patient. That is a common problem. Quite often when you enter into these marketing programs, you will pay based on the patients who, or the number of persons who actually become patients. If you do that, that is a red flag. There was no health information that was collected by the lead generator, meaning that that lead generator didn't screen these patients to identify whether they really were a potential patient. And the lead generator did not qualify the lead to make sure that they had insurance coverage or the other stuff. In short, they were essentially just acting as an entity that would come up with like the phone book and give you a copy of the phone book, but they weren't actually going through making contacts, finding people who could come or were interested in getting services at your facility. Now, on the other hand, to the extent you're paying them to do that type of stuff, find patients for your particular facility, the more they are involved in qualifying leads, finding out whether they're covered by insurance, gathering certain health data from them, the more likely they are going to be deemed to be not just generating leads, but actually providing referrals for you. And if your compensation to them is based on the number of referrals, there's a high likelihood that that could violate the federal fraud and abuse laws if it's dealing with federal program beneficiaries. In addition, you have to be aware of HIPAA. To the extent that you begin paying that patient or providing that patient or that marketing company to gather specific information about persons who become your patients, then they may, if they're collecting that protected health information on your behalf, then they're going to be your business associate and they're going to be covered by HIPAA. You're going to need to have a business associate agreement with them, and I suspect that those lead generation companies are not going to comply with the requirements of HIPAA for business associates, like have the security rule requirements in place and those types of things. So beware of HIPAA when you do those types of deals with those lead generation companies. All right, what about paying independent contractors based on commissions? You want to hire this person to help you develop leads or to generate business for you. You're hiring them not as an employee but as an independent contractor, and you're going to pay them X dollars per patient that they bring to you. Well, are you paying them to induce referrals? Probably, yeah, depending on, again, how much information they're collecting, whether they're qualifying, all of that. If they're dealing with government program beneficiaries, you got to make sure you fit within an anti-kickback safe harbor. If it's dealing with a physician that you're paying, you'd have to comply with Stark. In order to comply with those safe harbors, generally the compensation has to be set in advance, and that's not going to be set in advance in a situation where you are paying a per lead or per referral type basis, because the aggregate compensation is not set in advance. In addition, you can't pay based on the volume of value of referrals, but if you're paying them based on a referral, hey, you're paying them based on the volume of value of referrals, so you may not be able to fit within an anti-kickback safe harbor. The OIG has specifically warned against paying independent contractors a commission to generate referrals for you. They said, we are aware of many examples of abusive practices by sales personnel who are paid as independent contractors. We believe that if individuals and entities desire to pay a salesperson on the basis of the amount of business they generate, then to be exempt from the civil or criminal prosecution, they should make these salespersons employees where they can and should exert appropriate supervision over the individual's acts. So generally speaking, you can probably pay your employees a commission based on their referrals. Independent contractors, you better be darn careful if they are going to generate business that's payable by federal health care programs. What about if they're only going to generate, or you're going to pay them for private pay business? Again, check your particular state law. White coat marketing. The government has also expressed concerns about white coat marketing. What's white coat marketing? That's where you're having a trusted healthcare provider actually doing the marketing for you. The government is concerned by using that healthcare provider, they may have undue influence over the patient, and therefore they may take advantage of the patient. So the OIG has expressed concern over advertising through which a trusted healthcare provider recommends a product or service. The government, in an OIG opinion, said that there's a lower risk where the marketing is not done by healthcare professionals, so it's not the doctor actually sitting there making the recommendation. Of course, the information is accurate, not deceptive, that it's passive, it's not directly to that patient one-on-one, but it's still maybe just broadcast over the media, in general broadcast, not targeted towards a particular patient. Specifically, the government said many advertising and marketing activities do not warrant prosecution because of white coat marketing, in part because they are passive in nature, meaning the activities do not involve direct contact with the program beneficiaries, or two, the individual or entity involved in these promotions is not involved in the delivery of health care. The flip side of that is, if they are involved in health care and it's direct to the patient, there's a greater risk that you could be engaged in white coat marketing. So, real quick summary of the fraud and abuse laws. Bottom line is, do not advertise or use the following as part of your marketing program, especially for government program beneficiaries. Don't advertise waiving of copays or deductibles or insurance-only billing. Don't advertise prompt pay discounts, charity care, or write-offs due to financial need. Free or discounting items if you intend to rely on an exception for services that promote access to care and pose a low risk of fraud. So don't involve those, don't use those as marketing gimmicks. You should beware offering freebies to patients or referral sources. Beware receiving freebies from vendors or other entities who want your referrals. And beware paying contractors based on referrals. The bottom line here, ask yourselves, are you giving or receiving freebies in order to induce referrals, particularly referrals for items or services payable by federal health care programs? Again, the government has published a bunch of advisory opinions concerning different marketing programs. You can go to the website here and you can look for those. All right, we spend most of the time talking about the fraud and abuse laws because that's where the real exposure is, but you've got to be concerned about some other laws, particularly HIPAA. As you know, HIPAA requires you to maintain the confidentiality of protected health information. You can't use or disclose the information. you can't not only disclosing it to third parties, you can't use it internally unless you can fit within a particular HIPAA exception. Now, that applies to any individually identifiable health information. It's not just their health record, it's the patient's name. It's any other individually identifiable information concerning the patient. It's using their address, phone number, account numbers, URL, their IP addresses. That's all identifiable information. If you're using that in marketing purposes or disclosing it to a third party for marketing purposes, that potentially violates HIPAA unless you can structure your arrangement to fit within HIPAA. It includes photos, images, or videos. How many of you have gone into the dentist's office? You look up on the wall and there's that cavity-free wall of photos. How many times do you think that dentist got the HIPAA-compliant authorization to put that stuff up there? Probably not very often. That's a HIPAA violation. All right, what are the penalties? Well, anywhere of penalties of $100 to $50,000 per violation. In addition, you can get hit up with criminal penalties. So let's talk briefly about the rules. HIPAA says you may not use or disclose protected health information, including for marketing purposes, without the patient's authorization unless you can fit within an exception. There's the most important exception. It allows you to use or disclose the information without the patient's authorization for purposes of treatment, including the provision, coordination, management, or referral of care, and certain healthcare operations, which includes contacting patients with information about treatment alternatives and related functions that do not involve treatment. So you can call the patient to give them options unless you've otherwise agreed with the patient. So you can use it for treatment and healthcare operations unless you've otherwise agreed with the patient. Don't promise the patient you won't disclose or use their information unless they give you their authorization. You're not required to do that for purposes of treatment and healthcare operations. There's an exception, however. You can't use or disclose the information for purposes of marketing. You can do it for treatment and operations, but not for marketing. What's marketing? Marketing is communicating about a product or services that encourages the recipient of the communication to purchase or use the product or service. In addition, if that marketing involves financial remuneration, you've got to get the patient's authorization, and you've got to tell the patient that you're getting paid to engage in that marketing. Now, marketing does not include communications, certain types of communications. Communications to provide refill reminders, communicated about a drug, or for the following treatment and healthcare operations purposes, so long as you do not receive financial remuneration. You can call up and talk to the patient about their treatment. You can talk to them about your own health-related products or services, so long as you're not getting financial remuneration from a third party to have those discussions. If you are, then it becomes marketing and you can't use it. In addition, you don't need the patient's authorization for certain types of marketing conversations if it's in a face-to-face communication or a promotional gift of nominal value. So you can do the face-to-face communication about marketing, but you can't send them emails, texts, or other things. Now, those are kind of complicated rules. Here's the summary, okay? Generally, you've got to have the patient's authorization to engage in marketing. Marketing is giving communications about any other products or services, okay? You do not have to have the patient's authorization to engage in communications about treatment or healthcare operations to describe your own products or services unless you're getting paid for those communications. If you're getting paid by a third party to make those communications about your products or services, maybe Johnson & Johnson or some other entity is paying you to make those disclosures, make those communications, maybe some web-based company is paying you to make those communications, then it does become marketing, and you generally need the patient's authorization to use or disclose their information for those marketing purposes. Now, you do not need the patient's authorization for certain face-to-face communications if you're talking to the patient face-to-face, or if you're simply offering a promotional gift of nominal value. That's how those marketing rules work. What about fundraising? In the interest of time, just note that if you're going to engage in fundraising, you've got to comply with certain HIPAA rules if you're going to use the patient's information for fundraising. What about selling the PHI? Well, Covered entities or business associates may not sell protected health information unless they obtain the individual's prior written authorization, and that authorization has to disclose that the information that the covered entity is going to receive remuneration in exchange for the protected health information. If you're going to sell their information, you got to get the patient's information first. That means if you've got a lot of those big companies out there that want data, want big data, they may come to you and say, hey, provide us with patient information and we will pay you for it. You can't do it. You can't sell that information without the patient's authorization. Now, you can de-identify the information, and once the information is de-identified, then it's no longer protected, and you can sell that, but you can't sell individually identifiable patient information without the patient's authorization. If you are going to use a third party to help you in your marketing, and in the course of that you're going to provide protected health information to that third party, whether it's a web designer, whether it's some kind of a marketing entity, some kind of an entity that's going to get your patient's names or your patient's addresses or your patient email addresses or their text messages, text numbers, if you're giving that information to that marketing company to help you, that entity is going to become a business associate, and you're going to need a business associate agreement with that entity. Among other things, that business associate, along with you, is going to have to comply with the security rules. Part of those security rules state that information that you maintain is presumptively, it's supposed to be encrypted. Well, what about when it comes to texting or emailing patients? Maybe you want to communicate with your patients, tell them about what's going on at your facility, and you want to send it by email or by text. Well, that patient's name, their URL, their address, that is protected health information. If you're using that for purposes of marketing or to communicate with them, theoretically that's under the security rule, the presumption is that has to be encrypted, but that's not the way most of our text or emails work. Bottom line is the general rule is you can't communicate with your patient via email or text, via unsecured email or text, unless you notify the patient in advance and get the patient's agreement that you can communicate with them via unsecured email or text. The omnibus rule said you can't communicate with the patient for unsecured emails or texts so long as you notify the patient in advance that it's unsecure and the patient agrees to same. Absent that, without that patient's consent, then you generally can't email or text their information over an unsecure network. Remember that if you are going to engage in emails or text, there may be other laws that apply, including the CAN-SPAM Act, the Telephone Consumer Protection Act. We'll talk a little bit more about that in a minute, and also state laws that may govern your efforts to engage in emails or text to patients. Just a word about responding to negative reviews. You're out there on the web, you've done a good job of trying to market your facility, and the next thing you know, you get a negative review out there that you think is going to bother you. Your initial response is to blast that particular patient, respond to them so everybody knows what's really going on, but the bottom line is you can't. You can't do it in a way that's going to disclose patient information, including the fact that that person is a patient. That in and of itself is protected health information. Just because the patient discloses the information, it does not mean that you can. A bunch of providers have gotten in trouble because they have violated HIPAA by responding to negative posts. So what can you do? Well, you do not disclose protected health information in an online response. What you may do is you could ignore it. Chances are nobody will pay attention to it. Even if they do, maybe it increases your credibility knowing that there's one negative review out there when you've got 99 positive. You could take steps to encourage and emphasize positive reviews so you get more positive reviews that drown out the negative. You could contact the patient to try to resolve their concerns and ask them to obtain, either give you consent to remove it or to remove it themselves. That works surprisingly frequently. Or maybe you respond generically. You respond online by saying something to the effect like, we are sorry if anybody has had concerns. It is our policy or practice to address concerns. Anybody who has concerns, please feel free to contact us directly. Something like that that does not identify that person as a patient, does not disclose any of their protected health information or any specifics about that patient's situation. You may contact the online company to request removal of the complaint, but that doesn't happen very often. They're not real willing to do that. If the review is defamatory, you may threaten a lawsuit against a particular person who's posting that. That may or may not work. Sometimes it just throws fuel on the fire. Let's talk briefly about some of the rules for telemarketing, particularly the Telephone Consumer Protection Act. You guys need to be aware of this. If you are using pre-recorded calls or auto-dialed calls to a wireless number without, or to the home number without the recipient's prior express consent. Generally speaking, it's a lot more complicated than this, but generally speaking, you cannot use pre-recorded calls to a residence or pre-recorded or auto-dialed calls to a wireless number unless you've got the patient's consent. Now, there's an exception in that TCPA that applies to entities that are otherwise, or calls that are otherwise protected by HIPAA. A lot of people, healthcare providers, thought, well, fine, we're okay because our calls are all covered by the healthcare operations exception, so we can go ahead and make those calls. We don't need to worry about the TCPA. Unfortunately, in 2015, the FTC issued an opinion in which they defined covered by HIPAA very narrowly. They said that this TCPA exception only applies to calls specifically dealing with healthcare issues, like appointment reminders, lab test results. It does not apply to marketing calls or calls about the patient's account or those types of things. Therefore, if you are using auto-dialed or pre-recorded calls for those types of communications, you have to be concerned about the TCPA. Now, watch this TCPA issue very closely because that 2015 decision is now up on appeal. In addition, there are talks at Congress about modifying or updating the TCPA. In the meantime, however, if you are using auto-dialed or pre-recorded messages, make sure that you understand the TCPA and that you comply with those requirements, including getting a consent that satisfies certain requirements. There are other laws that apply to telemarketing, like the Telemarketing Consumer Fraud and Abuse Prevention Act, which generally prohibits deceptive and abusive telemarketing calls. There are calls, different statutes dealing with anti-solicitation of certain types of providers like DMEPOS. These are the federal laws. There may also be additional state laws that apply, particularly in places like California. You need to be aware of those particular laws. Anytime you engage in advertising, beware of false advertising. That may apply specifically under your Medical Practices Act. Most of your state medical practices acts or other professional practices, professional licensing acts, will have laws or standards that prohibit you from engaging in certain conduct in your advertising that they believe to be unethical. Things like misrepresenting or omitting material facts, creating unjustified expectations, promoting items that are not necessarily medically indicated, representing that an incurable condition may be cured, and so forth and so on. Make sure you're aware of those limitations and you structure whatever marketing campaign you're doing to fit within those parameters. If you fail to do so, bad things can happen to you. They could take, the licensing board could take adverse action against you or the provider's license. That can result in monetary penalties, loss of license, embarrassment. It could also give rise to malpractice claims or maybe claims under state consumer protection acts. The Federal Trade Commission and most states prohibit false, deceptive, or misleading advertising as defined in those particular acts. Be aware of those situations to make sure that your representations that you make in any advertising is truthful and accurate and consistent with the requirements of those acts. Testimonials and endorsements. You may have a patient, you may have an employee who wants to give you a testimonial. Make sure you understand the laws concerning that. For example, the FTC has issued guides concerning the use of endorsements and testimonials in advertising. Specifically, they're concerned about situations where you use an employee to give you a testimonial and don't disclose that this person's an employee. You generally have to disclose that they're an employee. With regards to testimonials about physician services, the AMA has published an ethics opinion dealing with those types of situations that's there on your website. real briefly, let's talk about some marketing limitations for certain types of providers. In general, if you are a Medicare plan, the government has placed certain guides or limitations on the way you can market your plan to Medicare beneficiaries. Those Medicare guidelines not only apply to the plans themselves, but those contracts that those Medicare plans have with you as a provider will contain limits that limit your ability to market those Medicare beneficiaries. Make sure you're aware of those limitations. If you're a provider of durable medical equipment, prosthetics, orthotics, and supplies, the government has put in place limitations on your ability to market Medicare beneficiaries. Make sure that you're aware of those limitations. That's a brief, very brief overview of some of the laws that are out there. There may be other laws that apply to certain types of providers like pharmaceutical manufacturers, medical device manufacturers. There may be laws that additional agencies that may be involved, so you have to be aware of your particular situation and know the laws that affect you. All right, in the couple of minutes I've got left, let me just give you a quick to-do list for your marketing, to do a checkup for your marketing. First, you should review your existing arrangements, particularly your marketing programs to patients. Do they involve inducements or freebies to patients, especially government beneficiaries? Do you advertise improperly the waiver of copays, indigency discounts, those types of things? Make sure you review it to ensure that you're complying. Make sure that you're training your marketing people concerning these things. Look at your arrangements with vendors and referral sources, including other providers. Beware offering them free or discounted items or services, anything that's less than fair market value. Ensure financial arrangements with physicians and other referral sources fit within the applicable safe harbor. That normally means that you need to have a written agreement, and it's not based on the volume of value referrals. Beware paying commissions to your marketers if they're independent contractors. Ensure your compliance plan addresses marketing issues, and make sure that you have trained your marketing department on these compliance issues. As I mentioned, these things are largely foreign to people who get a degree in marketing. When you go out and hire that person, they come in all bright-eyed and bushy-tailed thinking that they can do lots of really cool things that they can't do in the healthcare industry. Make sure that they understand and know the rules that we've talked about today and document that training. So if they do violate it, you can at least show that we told them, and therefore you can minimize your risk. Require review of marketing programs by your compliance officer, attorney, or other person who understands the rules, so you don't have your marketing department out there running amok. Require immediate reports of violations so that you can take appropriate steps. Make sure that you protect your patient's information. To the extent you're using a third party and disclosing information to that third party, execute business associates agreements with those marketing contractors. Do not use patient photos, quotes, or other identifying information without a valid HIPAA authorization and preferably a media release. Do not talk about specific patients at all without authorization. Even if you try to remove identifying information, it's just really easy when you get somebody up there talking, a provider or somebody else, and they start sharing individually identifiable information. Beware remuneration from third parties in exchange for marketing their products or services. You got an outside vendor that wants to pay you to market their services. Be very careful about that. You may be violating HIPAA. You may be violating the Anti-Kickback Statutes. Implement appropriate safeguards for email or text or other communications via the internet to make sure you're complying with the HIPAA security rules. Monitor your social media and make sure that your employees are not improperly disclosing patient information on media. In your advertising, ensure your statements are accurate and supportable. Do not overpromise or guarantee results. Include appropriate disclaimers like results may vary. Beware using photos, endorsements, and/or testimonials. Avoid high-pressure, direct contact, or white coat marketing. Be very careful in making comparisons with competitors. And don't claim expertise that you don't have or overstate your credentials. For additional resources, the OIG's website has a bunch of stuff dealing with the fraud and abuse laws, including additional training materials that you could use in helping your marketing personnel. That's it. I went through that stuff awfully fast, but hopefully it at least gives you an idea of some of the red flags that are out there so that you can review your marketing plans. If you have questions, by all means, feel free to shoot me an email or use that chat feature or contact me offline. Otherwise, good luck, and hope you have a good week.